Good morning. Heidi Oropesa with Florida You Judge. I hope everybody's having a great morning. We are live, and we're going to start with today's discussion. I have Brooke Elvington, attorney Brooke Elvington with me. She's an appellate lawyer. Her background is in also in criminal defense. Tell us a little bit about yourself before we start the discussion this morning.
Sure. Hey, Haiti. I've been practicing law now. It looks like 21 years. So I have a JD and a PhD. I'm a doctor in criminal justice. Most of my professional experience is in appellate and post-conviction litigation, and I've practiced in the second DCA now for most of my 21 years.
Okay, so you've done a bulk for many years, appellate work. Yes?
Yeah. Yes.
Okay, and good morning again. Heidi Oropesa with Florida You Judge. The call-in number is 813-221-9700. You can call. Today we're going to be talking about a Hillsborough County race. It's made national headlines. This is the case incumbent Judge Jared Smith in Hillsborough County. He's a circuit judge. And he made a decision that was appealed. The second DCA reversed it. It made headlines regarding a judicial waiver. It relates to abortion, but it's really not predominantly an abortion case as much as it is a law that's in Florida that judges have to look to make decisions about whether they're going to give underage girls a waiver to have an abortion. So good morning again, Brooke. Thanks for joining me this morning. We're going to talk about the cases. The case is Jane Doe appellant, and I'm going to go ahead and share it here. And I just start talking a little bit about the background factually.
Sure. Okay, so first of all, I should say that although we're here discussing Judge Smith, I'm not here to talk about Judge Smith. I do not know him personally, and I've never actually even appeared in front of him. So my statements are going to be related to the appellate decision and what I think it means in my view. So basically what you have in this case, we have Florida law, which is section 390.0114. And what that says is that if you are a minor child in the state of Florida and you want to have an abortion procedure, you either need the consent of your parent, or in the event that you cannot get the consent for a number of reasons, you can apply for what's called a judicial waiver procedure. And what that requires is that the minor must petition to a circuit judge and argue that she has the requisite level of maturity and responsibility to make the decision to have an abortion on her own without the involvement of her parent, okay? So when she applies for this petition, the court then has to conduct a hearing and take into consideration a large volume of facts that relate to very specific procedures or factors under the statute. So what we have here is a 17-year-old young lady who was recently pregnant. I don't know how many weeks, but it was very early in the pregnancy. She and her boyfriend determined that abortion was what she wanted to do. She was in school. She lived with with one of her parents, I believe. Her religious beliefs and that of her parents were typically not in support of abortion. She believed that if she was forced to get the consent of her parents, the parents would not agree to the abortion and would either require her to have the baby or, of course, perhaps give the child up for adoption. She, an issue that was in front of the judge or in front of the trial judge was her overall performance in school. Her GPA was a 2.0. She testified that she was now earning Bs. She worked several part-time jobs, but she didn't have any financial responsibility in the house other than things that she herself wanted to procure. She didn't have a driver's license. Her dad drove her everywhere she needed to go. Her dad refused to put her on an insurance policy, so she could not drive. She didn't have any siblings, so she didn't have any responsibility over younger children. She was not involved in any extracurricular activities at school. And she testified that the reason she wanted to have the abortion is that she wasn't financially secure and she wanted to join the military, and that could cause a hindrance. And she had long-term objectives of going to college, and I think she wanted to become a nurse. So that is, I think, somewhat of a recap of the factual history leading up to the hearing itself in front of Judge Smith.
Okay, but for those of you who are going to be voting or know of persons who are going to be voting in the Hillsborough County judicial race, that it has started. They've been campaigning, both Nancy Jacobs, who, by the way, I did invite Nancy Jacobs to come on, and she confirmed. This is my text message with her. She confirmed that she was going to come on with me and I invited both of them to come on. And the reason that I'm interested in discussing this is important. Voters need correct information about what's going on. I believe that candidate Nancy Jacobs and those of her supporters have made this a political issue and it's been misleading. I also invited a colleague of mine, Gretchen Cothran, who's a supporter of hers and has been commenting in the news about this issue, trying to get support for Nancy Jacobs. That's her right to do that. I consider Gretchen a friend. And she is a supporter. I invited her. There's another political activist out in Hillsborough who's been commenting prolifically about this case. I believe her name's Rochelle Reback. I tagged her yesterday on social media, invited her to come on and to have a conversation with the community as an activist. And I didn't get any response. Gretchen said she would try, but in any event, I just wanted to make sure that the public knows that I'm not trying for this to be a biased conversation. I want this to be a fair conversation. Brooke, you said have you ever met Judge Smith?
I've not.
You've never met him. Okay.
No.
So, and you've not made any endorsement in this race?
No, I have not.
And neither have I. So, but I did attend Candy Lowe's Tea and Conversation last Saturday. And what prompted me to want to have a conversation with the electorate on this case is because Nancy Jacobs was there. So was incumbent Judge Jared Smith, a community member, Elvis Piggott. He was there. He's a political activist. He's a clergy person, man, and leads a church. And he got to ask a question at Candy Lowe's Tea and Conversation. And he asked Nancy Jacobs, who was there, what she believed as far as consent, our community, our country, our state, the issue of, does she believe in parents being the ones that should give consent to their child, to their daughter, when she's considering an abortion? She said, I can't answer that question under Judicial Canon 7. He posed the same exact question. Oh, also Bernice Lauridin, who's a big advocate for Nancy Jacobs' campaign. I texted her and I asked her to come on. In fact, she was there and she asked Judge Jared Smith why he denied a 17-year-old from having an abortion. She was there. I asked her, I texted her and said she couldn't join this conversation. I want it to be a fair conversation. There's a call-in number here. It's live. This is live, 813-221-9700. Later on, after it's a pre-record, you can ask or make inquiries in the comment section. I'm happy to engage you or anybody else that's in the virtual town square. This is important. This is important. This is a circuit court race. And we have to be informed with truth and accuracy. That's why I'm here. Nancy Jacobs failed to answer the question. Elvis Piggott gave the same question to Judge Jared Smith, and he answered it. He started talking about the case and explaining the issue. Section 390.0114, Section C, or 6, subsection C. Go ahead, look at it, folks. We need to be informed. That's the way that this representative republic works. Listen, mailers have gone out already. Here's one that came out. This is a political action committee, okay, that put this out. Judge Jared Smith thinks he can rule on what you can do with your body. Okay. I haven't heard any of the supporters of Nancy Jacobs saying anything about the accuracy or misleading nature of this. I think this is very misleading. If you go ahead and read the opinion, I posted it so that you can become informed before casting a vote. Early voting starts tomorrow, August 28th to the August 21st. Judge Jared Smith thinks women are too dumb to make their own bodily choices. That has gone out. Do you think this is a misleading mailer?
Are you asking me? The answer is
I'm asking you.
absolutely yes, I do. It has absolutely no bearing on the opinion or the facts that were put into the opinion related to the trial court order. It would appear to me, from a read of the actual opinion, which is a lengthy order of 30 pages and includes a dissenting opinion, which means 2 judges agreed that Judge Smith needed to be reversed. One appellate judge thought that he should not be reversed. The opinion itself outlined all of the required factors, and it may have seemed initially when I talked about the facts that led to this case that a lot of these facts seem innocuous or somewhat irrelevant. But the truth is, under Florida law, all of these facts are absolutely relevant and necessary for a trial judge to consider. Because when a minor asks for a judicial waiver to have an abortion, meaning not to talk to her parents, not to get consent, the judges have to evaluate a large number of factors under existing Florida law. The court has to consider the individual's age, here it's 17, her overall intelligence, her emotional development and maturity, her credibility and demeanor, her ability to accept responsibility, and her ability to assess consequences related to what is a medical procedure that in all other circumstances, a minor child would, of course, need parental consent for. So all of these factors are required to be considered by the judge. And in fact, there's literally 20 years of appellate history that outline just how incredibly difficult this determination is for trial judges. That trial judges are positioned based upon our legislative requirements to make determinations that are almost impossible, right? To determine whether someone has the requisite level of maturity. So what the judges do in these cases is take evidence related to such things like academic performance or the level of responsibility that an individual may have at 16, 17 years old, and whether this type of evidence rises to the level by clear and convincing standards that the judge then has a firm conviction in this child's ability or a young woman's ability to make this decision on her own. This is a requirement positioned by the Florida legislature. So it doesn't matter what Judge Smith wanted. It wouldn't matter what his personal position was. In fact, his personal position is entirely irrelevant. He didn't discuss his personal position. He didn't reference his personal position in any way, shape, or capacity. And it's interesting because prior opinions addressing the same type of scenario, I found that judges sometimes did raise their personal opinions. None of that happened here. In this case, what the judge ultimately found is that the minor presented herself in somewhat of, I want to say, inappropriate fashion in front of the judge. He described her as being curt. He described her as interrupting the court when answering questions or asking questions. And demeanor, of course, is a factor that judges will and should consider. And in fact, in this scenario, they're required to consider. So ultimately, when this minor spoke and offered her testimony on a number of factors, including her academic performance, the judge found that she lacked credibility, that she did not show that she had the requisite level of maturity to make a decision on her own. And honestly, a read of the second DCA opinion, especially the dissent, outlines clear support for the judge's findings. Now, that, again, it's not my personal view, right? My personal view is irrelevant. The question is, were the judge's findings supported by the evidence? So if you look at the overall intelligence, that's a factor that's required. She testified that she had a 2.0 GPA, but she was currently earning Bs. The appellate court found that that was evidence of average intelligence, average. The Judge Smith, took issue with that, said this is not enough for me to find in favor under this particular factor. In looking at her emotional development and maturity, the judge considered her courtroom behavior and the way that she was conducting herself to demonstrate that maybe she didn't rise to that level. The court also considered the fact that she didn't have financial responsibilities beyond that of what she wanted to buy. Her parents provided everything for her. She didn't have a car. She couldn't drive on her own. She was entirely dependent on her family for her needs, which is, of course, what sometimes we expect of a 17-year-old child. In reference to her understanding of the procedures, she testified that most of her knowledge came from Google, and the court took significant concern with that and indicated that it may be that this minor did not appreciate the gravity of the situation or the medical risks and long-term risks that might apply to the procedure. So the bottom line is the judge considered all of the required factors, analyzed them carefully, did not insert any of his personal viewpoints, and I have no idea what they may be, but certainly did not input any type of bias. It's not alleged at the appellate level that there was any inappropriate bias. The appellate court simply disagreed with the judge, and I would say the majority, the two-judge majority, simply disagreed with the judge's analysis.
Okay, and we are not able to see his actual opinion, and some people have a problem with that, including me. Right. The fact that I can't read his actual opinion that was appealed, that's been sealed because she's a minor. I get it, but they can redact stuff from the opinion to not reveal her identity. So that, as they do in juvenile cases, we do criminal defense. There's juvenile case law opinions where they just initial the name of the child so that to not reveal. Right. So that I have a problem with that. Right. These appellate judges, again, 1 dissented. Right. Appellate judge dissented, did not agree with his colleagues. Mm-hmm. And remember, and I'm going to be talking about this soon because in our engagement as voters, we elect those who are going to be on the bench here in the state of Florida. We have the ability to do that. And with our representatives, judges here, there's with the appellate court and with the Supreme Court, they remain on the bench through retention. Yes, that's something that the voters decide. Every so often, you're going to see on your ballot, should we keep this justice on the Supreme Court and the appellate court? So read the opinion, become informed, because there's a lot of deception. Again, I have invited to participate in this discussion those who are advocating about as to that voters should take Judge Jared Smith off the bench because he's against reproductive rights. That's a lie. Whoever's telling you that is misinforming you. Okay? That is not true. This case is simply about Judge Jared Smith saying, should I give her the green light to get her the abortion, or should I go ahead and send her to her parents who are in a better position? I don't think that most people would take issue with that. Yet we have political activists out in the community giving recommendations as to who to vote for and saying, take Judge Jared Smith out because he's against abortion. No. It's a lie. You're intellectually dishonest. And it's 30 pages. Everyone should read it. But I do want to go over this, Brooke, just because I think this is important. I read it and I think, wow, look at this. Let's go. I just want to read this because this is something that's serious. This is the opinion, the second DCA opinion. When asked about the side effects of the procedure, the petitioner testified that she had used Google to get information because the clinic would not explain anything unless she had been granted a judicial bypass. She acknowledged that Google is not always reliable. Finding the clinic's website online, she learned that that risks of taking the pill include depression and the need for surgery if it does not work right. In her later testimony, she also identified abnormal bleeding and abdominal cramping and pain as possible risks, folks. She described abnormal as anything over 7 days. She said that she would go to the doctor if she was still having blood clots after the 4th or 6th day. She said that according to the clinic's website, after she is 10 weeks pregnant, she will no longer be able to take the pill and will have to have surgery instead. She said that she wants to be able to talk to the doctors at the clinic to make sure she fully understands everything before she goes through with it. The petitioner testified that long-term risks from the procedure could be difficulty having children in the future when she's ready because of an increased risk of miscarriages and also irregular periods. The petitioner testified that if she were to miscarry in the future, she would just deal with the consequences unless it's fairly significant and she had to go to the hospital. Okay, now listen, folks. Listen, for those of you who are out there saying, don't vote for and I haven't endorsed Judge Jared Smith or Nancy Jacobs, and I've refrained from commenting on this when I see this being mailed out and what's being said. You're a candidate, Nancy Jacobs, seemingly is allowing this to be politicized. You're not supposed to politicize the bench, okay? And kind of give an impression that if Nancy Jacobs wins, she cannot say that she will always, in every single case that comes before her, give a judicial waiver. Because if she says that, first of all, she's prohibited from the canons from saying that. But if I brought her on here, maybe that's why she didn't want to come. When I started seeking dates for her to come here to address the electorate, and she had committed to doing so, she then sent her campaign. She said, after further consideration and consultation, it has been decided that candidate Nancy L. Jacobs will not be participating in the Florida You Judge segment with candidate Jared Smith. Thank you for the invitation, however, Haiti. She doesn't want to be forthcoming and come on to talk about that. And she's making an issue about it, and there is no issue. Judge Jared Smith does not have the power to deny women abortions. This is not what this case is about. When you read those risks, okay, if you think that it's okay for a judge that doesn't know your child to make that decision, when you read all those serious risks instead of the actual parents, that's a problem. That's what this case is about. That's the law. Brooke said it's statute 390.01146C. If you don't like the law, you go change it through the legislature. Let's just take that judicial waiver mechanism out of the law if you don't like it, but it's on the books. And so when it goes before a court, a judge, whoever's hearing the case has to make that waiver. This is about, if you're going to be intellectually honest, I'm open to the supporters of Nancy Jacobs who have been commenting on this case, and I would say being intellectually dishonest about it and making it what it is not about abortion, when it's not about that. This case is not about that. This case is about whether a judge is going to decide whether a young girl has an abortion or whether her parents, Brooke.
Under an almost impossible standard, right? And I think that has to be explained and understood, that what we're asking these judges to do is very, very difficult. And in this situation, it would appear that Judge Smith did that he undertook to position the facts under the law as provided by the legislature and make a very difficult call. There's no evidence whatsoever that he was guided by improper bias or his own religious beliefs, his own ideological beliefs. There's no evidence to suggest that. It appears very clear that he isolated his analysis to Florida Statute 390, and he included an analysis of prior opinions, one of which was, and I don't know if this was in his order because we don't see the order, but one of the prior opinions was actually involved Judge Casanueva, who authored the opinion here. And it's fascinating because in that case, which was several years ago now, in an almost identical circumstance where the child was 17 and wanted to go to college, and in that case, she got A's and B's in school, Casanueva signed a concurring opinion that the child was not permitted to have the judicial waiver in that case. So it was denied and affirmed on appeal. He authored a concurring opinion denying an en-banc hearing, meaning he agreed with the appellate order under almost identical facts, which says these cases are incredibly difficult to do from a judicial perspective.
So are you saying that one of the judges that reversed Judge Jared Smith in a prior opinion, he denied a judicial waiver?
He wouldn't have denied the waiver. He concurred with the
denial.
majority. Yes,
Got
and
it.
he wrote a concurring opinion in that case.
Okay, so do you hear that, voters? Do you hear that, voters? One of the judges who reversed Judge Jared Smith in a previous case agreed with a judge denying a judicial waiver, denying the ability for the young girl to get an abortion with a waiver from the court.
I should note in that case, the record actually provided evidence that the trial judge expressed his personal opinions regarding abortion and that abortion was not appropriate. The trial judge did that. And ultimately, the majority in that case found that even if that happened, which it did, it was harmless. It had no bearing on the outcome, and the minor was denied judicial waiver. Judge Casanueva signed a concurring opinion denying an en-banc hearing. It's earlier, it's 2008, but also in Re Doe. And for lawyers out there, it's 973 Southern 2nd, 548. But it's an interesting read. And I'm not saying that to criticize Judge Casanueva under any circumstance. The point in raising that is to articulate how difficult these cases are, and that it has no bearing on a judge's personal beliefs or whether a judge should be hearing these cases based upon his or her personal beliefs. I don't even know what his personal beliefs are. I think we can speculate, but that's speculation, right? The point is, a sitting judge is required to analyze facts and make hard decisions. That's what this judge appeared to have done.
All right, well, we're gonna wrap up. It's 10:25. My laptop clock is wrong. I'm gonna have to update that, but it's 10:25. 5 more minutes. We're gonna say bye-bye. Have a great Saturday. But I just did want to, Brooke Elvington, super smart, super smart. I send her all appeals. I send her family law cases as well. She does family law, and I just wanted to show your information here.
I should say also, I did a quick look to see whether Judge Smith had previous involvement with the second DCA. In other words, have they taken issues with prior opinions? Does he have prior reversals? I did not find any. It doesn't appear that he has any previous decisions finding that he abused his discretion, at least in my limited purview. So it doesn't look like he's got significant history with the second DCA.
Okay, so that's the information. If you ever want to reach out about criminal appeals, post-conviction process, you can contact Brooke Elvington at 727-543-7188. And thanks for those who have tuned in. Again, reminder, tomorrow early voting starts and ends on August 21st. There's two candidates in this race, incumbent Judge Jared Smith and Nancy Jacobs. Again, for those that I sent a previous or an invite this week to participate in this discussion, and you'd like to come on as a follow-up and weigh in for the benefit of the electorate, I'm more than happy to coordinate this week in the next couple of days. Let's not wait till it gets too near the election final day of August 23rd when you have to go in person to vote to do so. But thank you for those that have tuned in. Hopefully you go ahead and you become informed. This is what the purpose of this platform is, to inform us all and share. Please share for those who are going to be making a decision in that race. Do you want to say anything else before we say bye-bye?
Brooke? No, thank you, Haiti.
Okay. Thank you, everyone. Have a great Saturday. Haiti Oropesa with Florida You Judge. Thanks for tuning in.